A federal appeals court just kneecapped California's per-purchase ammunition background checks, and the aftershocks won't stop at the state line. In Rhode versus Bonta, the Ninth Circuit held that the regime violates the Second Amendment under Bruen's historical tradition test if the state can't point to a genuine analog from history. It can't burden a core right today. It matters because ammunition isn't a luxury. It's what keeps arms in common use operable. Tonight, I'm cutting through spin, what the court actually said, what still stands, and where this fight goes next, including the possibility of rehearing or a Supreme Court petition. I'll show how this ruling interacts with other cases, like Duncan v. Bonta on magazines, and give you a practical checklist to stay compliant while defending your liberty. If you value clarity over noise, stay with me. Next, we'll break down the holding, the timeline, and the stakes. What the Ninth Circuit actually held in Rhode versus Bonta, a divided panel of the U.S. Court of Appeals for the Ninth Circuit affirmed a permanent injunction against California's per-purchase background check requirement for ammunition, applying the Supreme Court's NY State Rifle and Pistol Assen v. Bruen framework. The court concluded that California failed to demonstrate a sufficiently analogous, well-established historical tradition of screening every ammunition sale. Because ammunition is necessary to render firearms operable, the panel treated routine acquisition of ammunition as conduct within the Second Amendment's protection, meaning the state had to justify its rule with history, not policy preferences. The opinion tracks Bruen's sequence. First, the court recognized that ammunition purchases are part of keeping and effectively bearing arms. Second, the burden shifted to the state to show that its modern scheme aligns with relevant historical analogs. California cited surety laws, licensing practices, taxes, and various public safety measures. The panel found those examples materially different in how they operated: episodic, targeted, or conditional rather than universal and per transaction, and in why they were adopted, aimed at specific threats or misuses, not ordinary purchases by law-abiding citizens. On that record, the state's analogs did not bridge the historical gap, so the regime failed under Bruen. California further argued that point-of-sale screening advances the legitimate goal of keeping ammunition from prohibited persons. The panel acknowledged that objective but emphasized Bruen's limits ends do not validate, means absent historically grounded analogs. Because the state failed to carry its burden, the court held the scheme unconstitutional and left the district court's injunction in place. The ruling is targeted. It addresses the challenged ammunition background check system and related purchase procedures. It does not decide the validity of distinct regulations e.g., prohibited person statutes, storage rules, or magazine limits. Each must be assessed separately under Bruen. Procedurally, the state may seek rehearing or Supreme Court review. Mandate or stay decisions could affect on-the-ground timing depending on subsequent filings and orders. Under NYA State Rifle and Pistol Assen v. Bruen, modern regulations survive only if the government shows consistency with the nation's historical tradition of firearm regulation. The inquiry is textual and historical, not a balancing test. Once the conduct, here, acquiring ammunition to keep a firearm operable, falls within the Second Amendment's text, the burden shifts to the state to anchor its rule in historically grounded analogs that are comparable in both mechanism and justification. Applied to California's per-purchase ammunition background checks, that burden proved decisive. The state invoked familiar touchstones, surety requirements, status-based disarmament of dangerous individuals, licensing practices, and revenue measures. But read closely. Those sources regulate in a fundamentally different manner. They operated episodically rather than universally, were triggered by individualized suspicion or breach of the peace rather than ordinary commerce, and targeted specific risks or statuses rather than every law-abiding purchaser at the point of sale. In short, history reflects targeted, conditional interventions, not a blanket, transaction-by-transaction screening of ammunition purchases. Under Bruen, that divergence in both the how and the why is constitutionally dispositive. This does not mean Bruen outlaws regulation, it channels it. Measures aimed at keeping arms or ammunition from prohibited persons can withstand scrutiny when they track historically cognizable methods. For example, rules that turn on adjudicated status or concrete breaches of the peace. What Bruen forbids is the leap from those narrow, historically tethered practices to a novel, universal checkpoint imposed on every lawful buyer every time, because the record in Rhode versus Bonta failed to close that historical gap. The Ninth Circuit concluded the state had not carried its burden. The contrast with other 2A cases is instructive. When the court, sitting en banc, upheld California's large-capacity magazine restrictions, it credited analogs it deemed responsive to comparable risks through comparable means. Reasonable jurists can debate that assessment, but the analytic engine remains the same. Bruen demands concrete historical moorings. Where those moorings are missing, as with per-purchase ammunition checks, the regulation cannot stand. What changes now and what doesn't? The immediate takeaway is narrow but consequential. The Ninth Circuit's decision in Rhode versus Bonta leaves a permanent injunction against per-purchase ammunition background checks, subject to possible stays or mandated timing affecting when changes take effect. In plain terms, transaction-by-transaction screening is enjoined, but implementation depends on current orders, not headlines. If the injunction remains operative, point-of-sale checks and the fees, delays, and database mismatches tied to them no longer govern ordinary purchases by non-prohibited persons. Vendors should update compliance scripts, training materials, and avoid demanding now-enjoined procedures internally. Revise audit checklists and preserve a memo documenting good faith reliance on the court's order. Equally important is what does not change. The ruling does not invalidate prohibited person statutes, disqualifications, or distinct rules on storage, sensitive places, or record-keeping imposed by other laws. It does not decide litigation over large-capacity magazines or any separate ammunition-type limits. Each regime rises or falls on its own record under Bruen. Nor does the decision standardize rules beyond California. Interstate transport remains governed by the destination jurisdiction and any applicable local ordinances. Operationally, prioritize disciplined process, verify the mandate, and any stay before changing policies. Document transactions, invoices, timestamps, purchaser attestations to evidence compliance. Train staff to distinguish between enjoined checks and still applicable duties, age verification, federal prohibited person rules, lawful ID practices, and monitor official state and federal sources, guidance, and court dockets for updates. When orders shift, adjust immediately and accurately log the change. Compliance turns on the law as it exists today, and on the record you keep when it changes. Crossing a border with ammunition, and the legal terrain can shift instantly. The controlling principle is simple. The law of the jurisdiction you are in governs your conduct, not the law where you purchase the rounds. A California injunction does not dissolve requirements in neighboring states, and a permissive regime elsewhere does not immunize you. For prudent, law-abiding owners, compliance is layered. Start with federal baselines, then map state and local rules that add limits on possession, transport, or particular ammunition types. Even without California's per-purchase checks, maintaining point-of-sale documentation and retaining receipts remains wise. Close cases often turn on proof, not recollection. 2 anchors reduce risk. First, verify before you travel. Use official.gov sources, state codes, attorney general guidance, transportation pages, and check effective dates. Interim stays and emergency rules can move fast. Second, document contemporaneously. Keep receipts, invoices, match registrations, and training itineraries to establish when and where purchases and movements occurred. In close cases, proof, not recollection, resolves disputes. Treat vehicles like evidence boxes. Store ammunition in original packaging when feasible. Separate it from firearms where lawful and sensible, and avoid loose containers that can be characterized as concealed carry implements. If you must transit sensitive locations, school zones, courthouses, or federal facilities, plan routes and stops to minimize exposure to location-triggered offenses. Finally, keep perspective. The Ninth Circuit's ruling under Bruen undermines universal, per-transaction screening models, but it does not standardize interstate rules till higher courts or legislatures create uniformity. Cross-border diligence is non-negotiable. Your most reliable protection remains disciplined habits. Check official sources, document compliance, and adjust plans when legal conditions change. Recheck dates immediately before departure and upon arrival there. The litigation road ahead: rehearing, stay, Supreme Court, The Ninth Circuit's decision is a constitutional marker, not a final settlement. California can still petition for panel rehearing, rehearing en banc, or Supreme Court review. Each step carries procedural tools, especially stays, that can pause the injunction pending review. Timing matters. The mandate controls when judgment takes effect. A stay or delayed mandate can preserve the prior regime during appellate activity. Expect two themes from the state. First, it may be argued that per-purchase checks impose minimal burdens versus public safety benefits, urging broader analogies. Under Bruen, that framing struggles because outcomes turn on history, not balancing. Second, it may press status-based analogies, claiming modern databases are a contemporary means of excluding prohibited persons. The panel answered that history shows targeted, conditional mechanisms keyed to adjudicated risk, not universal screening of the law-abiding at every transaction. At the Supreme Court, certiorari is discretionary. The justices may wait for more percolation, especially given other Ninth Circuit firearms rulings, including the large-capacity magazine decision. Cert likely rises with a circuit split, an entrenched statewide policy with national impact, or recurring questions about how Bruen applies to ammunition acquisition. For owners and retailers, the takeaway is simple. Follow current orders, track official dockets and .gov guidance, and prepare for contingencies. Any shift, rehearing grants or denials, a stay, or a cert petition can alter obligations quickly. Professional compliance means watching the docket, reading the orders, and adjusting operations to match the law as it stands today. Monitor press releases and orders from the Attorney General closely. Your compliance and documentation checklist. Compliance is discipline. Before any purchase or trip, confirm the current statutes, Attorney General or DOJ guidance, court orders, mandates, and stays using official state and federal sources. Save what you relied on, PDFs or screenshots, with date timestamps and the URL. Keep the basics, receipts, and invoices for every ammunition transaction caliber, quantity, vendor, location, a simple purchase log noting purpose, and lawful ID/age check notes, without resurrecting any enjoined procedures. Follow your jurisdiction's storage rules and record changes with photos and dates. Travel demands a second check. Re-verify the destination state's law and any local ordinances 48 hours before you leave. When lawful and prudent, keep ammunition in original packaging and separate from firearms. Plan to avoid sensitive places, school zones, courthouses, federal facilities, and carry a compact trip folder with the statutes you relied on, your itinerary, match invitations or licenses, and ID copies. If you run a shop, range, or club, update SOPs the moment orders shift. Annotate each change with a legal basis and effective date. Train staff on what's enjoined versus still required, and run periodic internal audits with documented fixes. When rules move, a rehearing, a stay, or a mandate, assign a point person to monitor official dockets. If uncertainty persists, pause non-essential transactions. Consult counsel and document your reasoning. Above all, compliance turns on the law as it exists today, and your strongest shield is the paper trail proving good faith adherence. Here's the bottom line. The Ninth Circuit held that California's per-purchase ammunition background checks fail under Bruen's historical tradition test. That's a meaningful win. But the fight isn't over. Rehearing stays, or Supreme Court review could shift timelines. Act on what's binding today, confirm current orders. Train your team, document transactions, and verify rules before you buy or travel. The principle is simple when the state can't ground a restriction in history. The Constitution controls. I'll keep tracking Rhode, Duncan, and related cases so you have clear, lawful guidance, not noise. If this helped, subscribe and share it with someone who needs the facts. Fast.